السلام عليكم ورحمة الله وبركاته. أهلا ومرحبا بكم في ندوة المعهد الملكي للتحكيم فرع قطر. Welcome everyone. I will just start quickly in Arabic for the Arabic speaker, then we will move to the English. So أهلا بحضراتكم في الويبينار للمعهد الملكي للتحكيم في قطر. احنا الحقيقة الويبينار كان من المفترض أن يكون باللغة العربية، ولكن بما أن عدد الحضور كان أكثر في اللغة الإنجليزية فقررنا أن احنا نحوله للغة الإنجليزية، ولكن ما زالت الترجمة متاحة للغة العربية. فنرجو من السادة المتحدثين باللغة العربية ينزلوا على زرار الانتربريتيشن أو الترجمة، هيجدوا اللغة العربية موجودة، يقدروا إن هم يختاروا اللغة العربية ويستمعوا لنا باللغة العربية. So please everyone who would like to listen to us in Arabic, you have an interpretation button down. You can click on the button and they will be able to listen to the other channel in Arabic. Bismillah ar-Rahman ar-Rahim. Welcome to the arbitration clause in purchase orders. Is it legally binding if it's not signed? One of webinars we are doing in our branch. I'm gonna go. My name is Saad Hegazy. I'm the vice chair of the Chartered Institute of Arbitrators Qatar branch. I'm gonna walk you through the presentation. I'll make you quick introduction about today's agenda. So the speaker of today is Dr. Nasser AL-Adba. He's the managing partner of Omani Partners in Doha, Qatar, and also he is the Chartered Institute of Arbitrator branch chair. I'm going to give you a quick overview of the CIArb Qatar branch. We have established and officially launched in 2018. We actually established in 2017. A total number of board members currently are 15. We have around total of numbers 322 members currently in Qatar. We have a partnership and agreement with our partner, Qatar International Court and Dispute Resolution Center, who are hosting us under the QFC. The board, as you can see, the committee in 2020 we have two new committee where Dr. Nasser has been elected as a chairman, and you can see also some new faces on the board as shown. Our agenda for today, we will ask Dr. Nasser to make his presentation, then we will be later taking the questions and answers. Please note that the questions and answers will be asked in the Q&A button, so you can submit your question during the presentation itself, but we will be asking all the questions to the speaker at the end. Let me introduce to you Dr. Nasser Al-Adba. Dr. Nasser is an accomplished and highly recognized lawyer in Qatar and MENA region. He having studied and practiced law extensively throughout the world. He specialized in drafting and review of major construction contracts and practices, the field of international investment law and international trade and dispute resolution, having been chosen for the World Trade Organization rosters of panelists in World Trade Organization, WTO. He is also renowned for his skills as a commercial negotiator, mediator, and arbitrator in the arbitration and the alternative dispute resolution, ADRs. He is full-time assistant professor teaching the areas of public international law, ADR, and investment arbitration at Qatar University. Recently, he has been elected as the chair of the Chartered Institute of Arbitrators, CIArb Qatar and Qatar Financial Center, the branch. He has an academic education of a PhD in international investment arbitration from the University of Manchester, UK, GDL in international negotiation, mediation, and dispute settlement from Harvard Law School in the US. He has also an LLM from Graduate Institute of International and Development Studies in Geneva, Switzerland, and LLB from Qatar University in Qatar. So without being further delayed, I will give you the floor to Dr. Nasser. Please welcome him. So Dr. Nasser, the floor is yours.
Thank you, Saad, very much for this introduction. I would like also to thank the CIArb for their efforts, not to forget to our esteemed attendees today. As I know, the 3:30, the time now is busy. Rush hour for the people who are working now, but I would like to extend my thanks for the people who are attending today. So arbitration clause in purchase orders, is it legally binding if it's not signed? These questions came to me often last few months. So the practices of the world of commerce show that often the contracts are undertaken without exhaustive documentation. Only testimony of the supplier of such contract are purchase order, tax invoices, or exchange of emails issued by the supplier or service provider. These documents typically contain terms and conditions, such as arbitration clauses in case of potential dispute, and can be with no signatures. An arbitration agreement is the agreement to refer their disputes to arbitration, which is expressly or impliedly spelled out from a clause in an agreement. Separate agreement or document correspondence exchange between the parties. Moreover, an arbitration agreement can be derived from the exchange of means of communication. That communication including electronic means, if it can prima facie be shown that the parties are ad idem or in a legal agreement, even though the other party may not have signed a formal contract, it cannot absolve a party from the liability under the agreement. In a brief, the question arose on the existence of an arbitration agreement, its validity, and its operative included in purchase orders, or which called the general terms and conditions, which not been signed by the parties, or there is invoices or proof of delivery statement in light of New York Convention 1958, Model Law 1985 and its amendment 2006, and the Qatari Arbitration Law in 2017. Can we move to the other slide, Saad? So, as we stated before, there is 3 areas of a study in our webinar today, either the New York Convention or the Model Law or the Qatari Law in Arbitration and Civil Law. Pursuant to Article 2(1), Paragraph 1 of the 1958 New York Convention, reason the arbitrator convention states that to recognize an agreement in writing under which the parties undertook to submit arbitrable differences to arbitrate. And Article 2, Paragraph 2 of the Convention specified that an agreement in writing included in the arbitration clause in a contract or an arbitration agreement signed by the parties or contained in an exchange letter of or telegrams. We have had get a lot of case studies all over around the world. We got cases from United States. We got cases from Korea. We have got cases from India. Well, Indian have a special understanding for the purchase orders and the arbitration clause in it. We have also got some cases from Italy and France. And we will conclude our study today with what is Qatari law position. Can we move to the second page, please? Yeah, so the first case we need to envisage about the Lucas Lancaster Inc. versus Lark International Limited, and that have been seen in the District Court of the United States. A New York company, sent purchase order to Lark, a Hong Kong company that acts as a buying agent in Asia, for assorted clothing for Sears. The orders contained in an arbitration clause. Lark did not sign the orders, but helped Can select producers in the Philippines to fill the orders. when the orders were poached, Khan moved for arbitration for its dispute with LARC over payment. LARC asserted that there was no contract because it didn't sign the orders, hence couldn't be made to comply with the arbitration clause. However, the court decision, the parties are ordered to go to arbitration. There was a binding agreement under section 206 of the Uniform Commercial Code. An offer to make a contract shall be construed as inviting acceptance in any manner. And an order or other offer to buy goods for a prompt or current shipment shall be construed as inviting acceptance neither by prompt promise to ship or by the prompt or current shipment of confronting or non-confronting goods. LARC accepted by subcontracting for production of the goods and the shipment of which it monitored. Hence, the contract and this arbitration clause are presumed valid. There is another case, which is there is seller versus buyer, and it was a final award, and that was an ICC case number 20184. The sole arbitrator pointed out that the SPA had been concluded through an exchange of buyer's purchase order and seller's sales confirmation, both sent by email. Seller's sales confirmation expressly referred to seller's general terms and conditions, which contain the arbitration clause. The sole arbitrator agreed with the seller that an arbitration clause in a sale or purchase confirmation met with written form requirement of Article 2, Paragraph 2, if the confirmation had been subsequently accepted by means of another communication in writing from the party which had received the confirmation to the party which had sent it. This had happened in the present case, since the parties had been in continuous communication by email following the delivery of the goods, and buyer had challenged none of the conditions in seller's general terms and conditions. Can we move to the other slide? And now we are moving to Italy, judgment of September 1, 1977, Court of Appeal in Florence, an International Council for Commercial Arbitration. The Court of Appeal of Florence held that arbitration clauses in purchase orders signed by an American buyer and sent to an Italian seller who did not sign or return them constituted a valid agreement to arbitrate because subsequent invoices that referred specifically to the purchase order were signed by the seller. The court observed that under Article 2 of the intention of the parties need not to be expressed in the same document, and the agreement may be contained in the exchange of letters or telegrams. There is also cases of jurisdiction based on unilateral model law, 1985, and its amendments, 2006. The Article 7 in model arbitration law stated that the arbitration agreement shall be in writing. And then it is stated an arbitration agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally or by conduct or by other means, and that open up the matter of the arbitration to not be inexplicit. The requirement that an arbitration agreement be in writing is met by an electronic communications if the information contained therein is accessible so as to be usable for subsequent reference. Electronic communication means any communication that the parties make by means of data, message. Data, message means information generated, sent, received, or stored by electronic, magnetic, optical, or similar means. In US cases, we have a case which called, the parties called Universal Oil Product Company versus SCM Corporation. The court being of the opinion that the defendant's motion for a stay of the action pending arbitration should be granted for the reasons that, one, after a survey of defendant's Chicago plant made by plaintiff on its own initiative and after some initial negotiations, plaintiff submitted to defendant a written proposal dated 18 September 1976 to furnish a catalyst furnace for the price of $17,100 or $17,000, later increased to $18,000 as a result of inclusion of additional minor items. This proposal wasn't signed by either parties. Thereafter, under date of 7th March 1968, defendant sent to plaintiff a written purchase order signed by defendant purchasing agent referring to plaintiff's proposal of 18th September 1976 and ordering the furnace subject to the conditions on the reverse side of the purchase order, paragraph 9 of which reads, any controversy or a claim arising out of or relating to this contract or the breach thereof shall be settled by arbitration. Pursuant to defendant purchase order of 7th March 1968, plaintiff shipped the furnace to defendant's Chicago plant where it was installed. After some difficulties in attempting to get the furnace to function properly, it finally exploded on 26 November 1968, causing injury to some of defendant's employees and rendering the furnace useless. A dispute has arisen between the parties, plaintiff demanding that defendant pay the purchase price of the furnace and defendant claiming that the furnace was defective and not properly designed and constructed. Defendant has demanded arbitration of the controversy in accordance with the paragraph 9 of the purchase order, which had been agreed on the 7th of March 1968, and the plaintiff has refused to proceed to arbitration and has brought an instant action in the court to recover the purchase price of the furnace. Defendant purchase order of 7th of March 1968 being a counteroffer rather than an acceptance of plaintiff's proposal in September 1976. Corbin on contracts created in a plaintiff a power of acceptance which was exercised by plaintiff performance in shipping the furnace pursuant to the terms of the purchase order. Since the instant action involves a controversy or claim arising out of or relating to the aforesaid contract, as to which the parties have agreed to submit to arbitration, defendant is entitled finally to an order staying proceedings herein pending arbitration. And this case is a reference and the precedent in the US courts. The other case is, yeah, we have finished that, Saad. We have to move to the other case.
Sorry, Doctor, which case? You're gonna go back?
No, we finished this. We finished this just now.
Okay.
The University. So in the Southern Enameling Corporation versus General Bronze Corporation, where a seller of construction material was directed by telegram to enter buyer's numbered purchase order, and later confirming telegram stated that purchase order would be issued, the court held that seller's purchase order and not the telegram or letter constituted the completed contract, and subsequently seller was bound by the terms of the order, which stated that New York law should govern construction of the contract and that arbitration was a condition precedent to any right of legal action. And the other case, the Trends to Fashion Incorporation, a Avalia Group, where oral purchase orders were subsequently honored by a written contract containing broad arbitration clause, and where buyer did not object to the contracts and accepted the seller's good and paid for them, courts held parties entered into binding and enforceable written agreement to arbitration, even though purchaser did not sign the agreement. Now we are coming to India, and I am sure that our Indian guests today, they will be surprised because we have two approaches. There is approach number one, which is India cases on the validity of arbitration clause in purchase orders and invoices. And the most prominent case is MRICS Corporation versus Baikoti Exports and Ors, whereas Delhi High Court concluded that it is true that letters, telegrams, or other means of telecommunications could also contain an arbitration agreement. But that requires proof that such letters, telex, telegrams, etc., were exchanged by the parties that is mutually delivered and actually received by each other. Therefore, the fact of delivery of such invoices and the receipt of the same was considered sufficient for the purpose of establishing the existence of arbitration agreement. There is another important case, which is Luis Fernandez versus Jivatalal and Ors. Delhi High Court, under the Arbitration Act 1940, took into consideration the conduct and the commercial dealing of the parties to conclude the prima facie the purchase orders or invoices demonstrates that the parties have acted upon the same, and therefore the existence of the arbitration agreement was sufficiently established. And we have another case, which is the Smita Conductors Limited versus Euro Alloys Limited in the Supreme Court of India, and that is established in 2001. The India Supreme Court has enforced an arbitral award, notwithstanding the fact that arbitration agreement was neither signed nor contained in an exchange of documents. It held that the party, in particular, by opening letters of credit and reliance on the contract and invoking the contract force majeure clause, accepted the terms of the written contract, including the arbitration clause. The other approach of the Indian cases, which the invalidity of the arbitration clause in purchase orders and invoices, and we have an established cases for that as well. Can we move to the next slide, please? We have a case which is the plaintiff or the claimant concrete additives and chemicals versus SN Engineering Services. And recently, the Bombay High Court, in a judgment delivered on 17th January 2022, held that the tax invoices containing an arbitration clause or agreement, even though accepted by the respondent, doesn't constitute a valid arbitration agreement. And to give you a little background, an application was filed under Section 11 of the Arbitration Act in India for appointment of an arbitrator on account of certain dispute between the parties. The purchase order issued by the respondent did not contain an arbitration clause or indicate that there is an arbitration agreement between the parties. While executing these purchase orders, the applicant issued tax invoices. These tax invoices in the printed forms contained certain terms and conditions, one of which was the arbitration agreement. The question which required answer was whether the said clause in the tax invoices would constitute a valid and binding arbitration agreement between the parties as contemplated under Section 7 of the Act. The judgment and the court held that the issuance of tax invoices by the applicant is a unilateral act on the part of the applicant, and the clause as contained in the said tax invoices doesn't indicate that there is an arbitration agreement between the parties as contemplated under Section 7 of the Act. And the second, the acceptance of tax invoices represent the acceptance of the delivery of the goods and the payment to be made under the said invoices, and doesn't indicate any consensus agreement between the parties to refer the dispute for adjudication or arbitration. The contract between the parties is born under the purchase orders, and the said purchase orders do not contain or make any reference to an arbitration agreement between the parties. For these reasons, the court held that there is no arbitration agreement between the parties, and the application was rejected. We have another case, which is Surya Processors Private Limited versus Shri Jai Gurudev Textile Agencies. In this, the Delhi High Court took into consideration the conduct and the commercial dealings of the parties to conclude that prima facie the invoices demonstrate that the parties have acted upon the same, and therefore the existence of the arbitration agreement was sufficiently established. Now we finish from our tour, international tour among the all the Western and Eastern countries, and we have seen that most of them are accepting the purchase orders and the arbitration clause in it, whether is it signed by the other party or not, since there is direct communication between them about it. Now, what is the position of the Qatari law? The arbitration agreement in the Qatari law stated in the Article 7 of the Arbitration Law in 2017, which stated that the arbitration agreement is the agreement of the parties, whether they are legal persons or natural persons, having the legal capacity to enter into contracts, to refer to arbitration, to decide on all or some disputes that have arisen or that might arise between them in respect of a defined legal relationship, whether contractual or non-contractual. The arbitration agreement may be a separate agreement or in the form of an arbitration clause in a contract. And Article 3 and Paragraph 3 stated that the arbitration agreement shall be in writing, otherwise it shall be invalid. The arbitration agreement shall be considered in writing if it is contained in a document signed by the parties, or, and we have to underline or here, it is in the form of paper or electronic correspondence, or by any other means of communication which allows for written proof of receipt. The arbitration agreement is considered to fulfill the requirement of being in writing if one of the parties claims that such agreement exists in the statement of a claim or the statement of defense, provided that the other party doesn't deny such existence in its defense. And I would like to have to stop a little bit in the paragraph 4. The paragraph 4, in my opinion, it is the most flexible paragraph in all the arbitration laws in the Middle East. Means that if the one of the parties, who either the claimant or defendant, submitted their defense or statement of claims or the defense in the court, no objection from the other party, then the other party has not the right to deny the existence of the arbitration clause based on this article. And I would like to hear the Qatari legislator on taking the initiative on this matter. Now, if we move to the civil code, can we move to the other slide? Article 64 of the civil code stated that without prejudice to any special formalities that may be required by law for the conclusion of certain contracts, a contract shall be concluded from the moment an offer and its subsequent acceptance have been exchanged if the subject matter and cause of such contract are deemed legal. And Article 65 of the same code stated that in its first paragraph, an intention shall be expressed orally or in writing by a commonly used sign by actual consensual exchange, and also by conduct that in the circumstances leaves no doubt as to its true meaning. And this is very important. A declaration of intention may be implied when neither the law nor the agreement nor the nature of the transaction requires that such declaration be expressed. So according to the Qatari law and the above stipulations, we believe that the arbitration clause in purchase orders accepted by the other party by performance of the purchase order itself is considered a valid and operative arbitration agreement. An arbitration agreement may also be proved by a written editor signed by the parties and may be proved by what the parties exchange in the form of paper or electronic messages, or in any other form made by means of communication that allow proof of receipt in writing. Although the proof or denial of the mutual consent of the contractors to arbitration is a matter of merits by which the court appreciates without the Court of Cassation control, provided that its appreciation being consistent with the constant in the documents and papers. The arbitration agreement, like any agreement made by the convergence of two mutual consents, which indicates that the agreement to arbitration may be explicit by the parties expressly declaring their intention to agree to arbitration either as a clause in the contract or as agreement submission. An explicit declaration of intention may be made by taking a position that doesn't leave the circumstances of the situation into question, its significance as to what is intended. The judge shall be independent by estimating whether or not the agreement has been obtained or not, and on conformity of the acceptance to the offer as he draws from the evidence before him. As a conclusion, practices reveals clearly that national courts have sought to adopt two varying and conflicting approaches. First approach is the arbitration-friendly approach, and where courts relies on the intention, conduct, and the nature of commercial dealings between the parties to conclude the existence of an arbitration agreement printed on an invoice or purchase orders and executed by the other party. Court, when I mean executed, not signing, executed mean he have done what's been agreed upon. Court hold that the arbitration clause in an invoice merely indicates an offer that is required to be accepted to constitute an arbitration agreement under the arbitration legislations. The evidence of consent had been found in the party's conduct in performing the contract. In situation where a party doesn't sign the contract or retain a written confirmation, nevertheless perform its obligations, many courts have held that such conduct amount to a tacit acceptance of the terms of the contract, including the arbitration agreement. And now we will move to the non-arbitration friendly approach. And we have seen that in some jurisdiction around Qatar, like in Kuwait, for example, and UAE and Morocco. So for the judiciary, which considers arbitration to be an exceptional dispute resolution, since it takes away jurisdiction from the judiciary to resolve the disputes, the arbitration agreement must be explicit and not implicit. Thus, the arbitration agreement must be interpreted narrowly. Accordingly, the arbitration clause in purchase orders issued by one party and performed by the other party may face obstacles to its validity and execution to the judicial approach. In Kuwait, for example, arbitration stated that arbitration is an exceptional way of litigation. The scope of this exception must be clear, explicit, and unequivocal. And that was a judgment in Kuwaiti court in 1992. In UAE, the decision in the judiciary of the court is that the right to litigation is legitimate, right, annexed by the constitution to all in order to defend a right or to defend, and that the principle is that the jurisdiction of the judiciary is a general jurisdiction that extends to any dispute that occurs within the state or affect the right of one of the citizens in accordance with the general rules of the jurisdiction of the court. And then it is stated that except for what is excluded by the law, by a special provisions and within the narrow scope specified by that, or in a matters in which conciliation is permissible, and that the litigant agreed on arbitration, and that agreement was stated in an express form expressing a valid will be give up the right to litigation and to choose arbitration as a means to resolve the dispute that has arisen or may arise in future. And that was come from the Federal Supreme Court Civil and Commercial Judgment in 2009. In Morocco, the agreement to arbitrate is an exception that is interpreted narrowly, and arbitration can only be resorted to if there is an express agreement on arbitration, and that being produced in Morocco in 2010. I think we have covered most of it. Saad, thank you very much for listening, and I really appreciate your attendance for today's purchase order and arbitration clause in it.
Thanks so much, Doctor. So before we move to the questions and answer, I have some questions. First, I would like to ask you myself, then we have some other questions if the time allows also on the Q&A section has been written by some of the attendees. So the first question I would like to ask you on the same matter. So now after this discussion, does the Qatari laws actually considers the implicit arbitration agreement in general?
Well, to be honest with you, Saad, we have a running case now in the court, which we have the same concept on what is webinar today on. In my point of view, I think the civil code, the arbitration code support that. The civil code, which contains the general rules of agreement, allows for the implicit expression of intent and the implicit agreement. And the concept of writing an arbitration agreement has a broad concept that includes what is contained in correspondence, even electronic, as well as the performance of the contract that contains an arbitration clause without objection or reservation to it. Yes.
Okay, thank you, Doctor. So based now on the outcome of this webinar, so if the performance of the contract, which is contained in arbitration clause, this performance without objection or reservation to it, accepted by the arbitration tribunal or the court in the Qatari laws?
Okay, so no objections or reservations, and you have been stating that clearly. If you send me a purchase order, and that purchase order has terms and conditions, and you are the seller, or you are the buyer, I am the seller, and I did not object that. Of course, the effective rule of interpreting the agreement in a manner consistent with the true orientation of the parties' intentions, and bearing in mind that the expression of intention in the conclusion of the contract may be by conduct or a position expressing the convergence of mutuality of the two intentions.
So let's take some questions from the floor. I have one of the questions is very big, so I will keep it to the end. So Nell is asking what distinguishes the arbitration-friendly and non-friendly approaches. So how is this to be identified?
Well, we have to see the precedent and the cases in the local courts of each jurisdiction. We have seen the US courts are toward the implicit arbitration agreement. That means we don't have to sign both the both parties of the agreement should sign that agreement. However, we have seen in India, there's two approaches of the Delhi court and the Bombay court. The Delhi court, they are with the implicit arbitration agreement, but the Bombay court, they refuse it. We have to see the precedents of each jurisdiction.
Okay, so one of the big questions is from Khalid Al-Ansari. He's asking, so what would happen in the case there was a contract signed by both parties, which include an arbitration clause, and then after the execution, the contracted order, after executing the contracted order, there was a purchase order that was sent from one part to another that had a deviation from the original arbitration clause. The receiver of the purchase order did not notice the changes and worked it to the contracted order and they sent it. Then conflict arose due to the performance, and then the purchaser said they wanted an arbitration as per the purchase invoice, which clause would be valid as the receiver did not notice the deviation of the original arbitration clause, and therefore, so this is the first question. Therefore, it did not agree on it. Simply performing according to the invoice is not fair decision. What's your opinion? So it's a big question.
Well, yes, but thanks Khalid Al-Ansari, and thanks Saad for this. There is many forms for this kind of disputes, whether the arbitration clause is in the main agreement, maybe the purchase order did not include the arbitration clause, maybe the purchase agreement has a local court, which is in vis-a-vis the main agreement. We have many scenarios. In a brief, I would like to answer Khalid's questions, but I need him to send me an email about it to adhere it and to understand it.
I think it's needed an email because this is like, a big question. But before
send it to me, Saad, and I will forward the answer for you because I need to understand what's the matters. Exactly.
So Khalid and whoever would like actually to ask more questions, you can contact Dr. Nasser on the email written here. So this actually is recorded also a lecture or a webinar, and it will be published on the CIArb website. In addition, anyone would like to have a copy of the presentation with Dr. Nasser permission, we can send him the this PDF presentation also. He can send us email on our email account. So I think, Doctor, these are the most of the questions. If there is no more questions, there is also one more question. What is the remedy if one of the parties to the contracts alleges at a later stage that it did not fully understand the implications of the agreement?
What's the question again?
What is the remedy if one of the parties to the contract alleges at a later stage that it did not fully understand implications of the agreement?
He did not understand the implications of the agreement based on the performing the agreement itself, or based on the arbitration clause in it.
It's not clear. What is the form of words the contract alleges at the later stages? Like after the conclusion we have drawn from this webinar that he said, okay, I did not understand actually what I was signing or these implications of these agreements or the purchase order. So this is what you are trying to say, only arbitration agreement. Kishore, it speaks only about the arbitration agreement.
If he's talking about the arbitration agreement should be, in my opinion, should be performed by the other party. If it's performed by the other party, then they have to go to arbitration.
Yeah. Okay. So another question from Nell: if the arbitration clause in the contract does not specify the seat of arbitration, but the law of Qatar is specified as the law of the contract, will the Qatar courts allow the arbitration in Qatar? So this is out of the subject, but I'm sure that Dr. Nasser can help.
Well, the seat is the legal seat, means where is the annulment against that arbitration clause brought inside the local court, which is local court here is Qatar. So it will be Qatar, of course. Yeah.
Okay. So Mirza is asking kindly. Okay, so this is not a question actually. She or he is asking about kindly guide us regarding the recognition and the enforcement of foreign commercial arbitration awards in Qatar. So we can make another session about this subject, I think, because this is a subject, wide subject. So if a party submit a claim for arbitration through KICA, so this was a continuing for one of the questions. So this would be the last question. One question more from Michelle. In a situation where an organization makes it purchases by BOs, purchase orders, and the quality not well described, what happens when the organization rejects the items supplied and the supplier brings this to arbitration? An example is the IT spectrum.
Okay, so in agreement to save the rights of both parties, it should contain a specific information about the products. And if the specific information about the product is not described well in the agreement, then we will check in which called, if it's in Qatar, for example, there is a standard of Qatari products. I think it's based on the engineering wise. There is a minimum standards for those things, and if it's not upon the standard of those things, yes, they can take them to arbitration. If it's the same standard or better than those standards, I think there is many negotiations and discussions between the parties or between the parties' lawyers and the court on what is the quality, whether who is performing what. And then the expert opinion, you, Saad, and your people, they are going to do their homework based on the expert opinion. Is this product is sufficiently to the or sufficient to meet the parties' desires or not.
Okay. So thank you, Dr. Nasser. So I don't think that we will have time to take more questions. So thank you everyone for attending today. Before we move, we would like also to remind you that our branch has a LinkedIn page, and also we have many channels of communications. So please communicate to us. We will be having at least 1 monthly webinar in the upcoming period, and also we are planning for one physical event. It's coming very soon. We will be announcing it later. So thank you so much, Dr. Nasser, for your time today for discussing this important matter. Thank you so much for the attendees today for taking your time during the busy days and attend so much actually important topic. It was new actually for me myself. Thanks everyone, and hopefully we will be seeing you again in one of the our webinars and meetings. Thank you so much. Have a good day.
Thank you very much. Have a good day.